Should the attorney represent the business or business owner? So here's the context. You are a business owner and you would like to hire a business attorney to help you, but really to help your business. And the attorney says, I need to identify who is the client. Is the client you as an owner or is it a business? And you might say, why does it matter? It matters not right now, but down the road for some really important reasons. Let's talk about those. Let's say, for example, that you no longer own the business down the road. Let's say you sell it. Or you no longer own all of it. You bring in another investor or another owner. Or let's say, for whatever reason, an ex-spouse gets half or a creditor gets some sort of rights. If the attorney's fiduciary duties are to the business, in other words, if the attorney represents the business, then the attorney-client privilege is to the business. And business owners generally have access to the communications between the attorney and the business. So that's one important reason, attorney-client privilege. Here's another important reason. An attorney has a duty of loyalty to a client. There are elements of that duty that exist even after the representation has ended. So let's say, for example, that an attorney has a fiduciary duty to a business. And then let's say that down the road, you have a second owner come into the business. You sell half the shares, you bring in an investor because you want to bring money, whatever the reason may be. Now all of a sudden, your individual interests are not exactly aligned necessarily with the interests of the business. Now they may be for a while, but let's say, for example, you start taking money out of your company improperly. When you own the business yourself, that didn't really matter. You had to make sure the IRS got their fair share of taxes, but aside from that, if you're stealing from your own company, you own the company, it doesn't matter. But if there's another business owner there, now the question is the attorney's duty of confidentiality, duty of loyalty, and other ethical duties under state law to you as the business owner or to the company as an entity? This is such an important issue when there are multiple owners or multiple investors, or whether there are messy issues affecting the company and the business owner has different risks or different interests. So let me tell you how I handle this. I usually prefer to represent the business owner, and the business owner can have me serve the company, but my fiduciary duties are to the business owner. If I were representing the company in a lawsuit and then later another owner came in, I would have to take a careful look at state ethics rules regarding whether I maybe need to withdraw. One of the issues is if an attorney represents both an owner and another party, like a business, and there's a conflict of interest between the two, as a general rule, the attorney needs to withdraw from the case. So, although it might seem really trivial and frivolous to worry about does the attorney represent the business owner or the business, my general approach is, as an attorney, to represent the owner. So I have very clear duties. I'm looking out for the individual, the human, even if those interests at some point conflict with the business. If you have other questions about things we've discussed or other legal topics or business topics, topics of importance to entrepreneurs, CEOs, and leaders running companies, please feel free to add them into the comments section below. You can subscribe to our newsletter to get an email update at aaronhall.com/free. I'm Aaron Hall, an attorney for business owners and entrepreneurs. This is an educational program so that you can spot issues to discuss with your attorney, avoid common problems in companies, and hopefully enjoy the rewards of a more successful company and life.